there is a contract and there are two parties in the contract, both have agreed to certain terms, and then there comes a third party and they want to impose certain contractual terms. Would they be able to do that? Well, the answer to this question lies in this video. So in this video, I'm going to be talking about a very important doctrine, a principle in the common law known as privity of contract. After discussing privity of contract, I'm going to be talking about how it's related to deeds of collateral warranty and how that's applicable in the construction industry. And then I'm going to be talking about subcontracting. So how subcontracting contracts would utilize this concept of privity of contract. Let's start off with privity of contract. So parties have agreed on certain terms and the contract is now enforceable. Then there comes a third party, as I said. That third party wouldn't be able to enforce any terms on any of the parties that were involved, the original parties that were involved in the contract. Now, unless that third party, there was an intention for that person to be included in the contract when it first started, otherwise there is no way that they can enforce their terms and conditions. And as an authority, this case that you see in front of you, the Dunlop case, talks about this concept of privity of contract. But in order for me to explain it to you, I need to make it related to construction industry. So I have this image that you see in front of you. Um, three parties: party A, party B, and party C. And in this situation, we're talking about one party, party A, that manufactures a certain material. So let's say roofing insulation, and it wants to distribute that material in the market. So what it does is it contacts party B, which is a distributor of construction materials, and it asks the party B to distribute that material in the market. And so a contract is established between party A and party B. Now, as terms in the contract, party A specifies that party B cannot sell that material for a price less than, I don't know, let's say $5 per meter or something like that. So there is a specified price, and below that price, party B cannot sell that material to anyone. So party B is a distributor. What it does is it contacts party C, which is a shop that sells construction materials to customers. And a contract is established between party B now and party C. Party B gives the material to party C, and it asks party C not to sell the product below that specified price that it had in the contract between party A and party B. And then party C goes on, sells, a customer comes in, sells the product for $3 per meter instead of $5. Now, party A was notified of this. So party A was notified that party C sold the product for less than the specified price that it had originally as a term in the contract between it and party B. Can it enforce that specific term? The answer is no. Based on privity of contract, the actual contract, the original contract was between party A and party B. Now, what happened between party B and party C, party A was a third party too. It cannot enforce its terms on party C, and hence, if party A were to sue party C, nothing would happen. So party C won't have to pay damages to party A, and that's the concept of privity of contract. It's still strong in Australia, so it's applied in a lot of cases. Having said that, however, there is this one special case where privity of contract wasn't applied and the third party was allowed to enforce contractual obligations, even though that third party wasn't originally in a contract that was between two parties. So, but generally speaking, it is still strong in Australia and it is enforced. Now, having discussed what privity of contract is, let's move on to this concept where it's applied in construction, and that is the deeds of collateral warranty. Let me first describe what a deed of collateral warranty is. So it's used to cover the doctrine of privity of contract, and it's in a situation where you have a third party, and that third party wants to impose the terms. Now, privity of contract wouldn't allow that third party to impose its terms, so the way to handle this would be through a deed of collateral warranty, and that's when the third party would be able to impose its terms. A situation where that would occur is, say you had a builder developer and there is a consultant, structural engineer. And the builder developer would request a structural engineer usually to provide a deed of collateral warranty to third parties. And the third parties would be whoever the future building owners would be. And that way, the structural engineer promises these building owners, the future building owners, that the design has been carried out with reasonable care and skill. Now, this is very why a developer would do that is because it's very attractive to a prospective buyer to know that the building would still under warranty and that the structural engineer would guarantee the work. Other applications in construction where they would utilize a deed of collateral warranty, a principal would sometimes require the head contractor to promise third parties that the work that they deliver is to reasonable care and skill. Principal at the same time may also require that the head contractor obtains a similar collateral deed from the subbies, so from the subcontractors. And in that situation where the subcontractor offers the collateral deed, what would happen is that any future building owner, so any person that comes in and purchases the project, they will have a course of action to sue the subcontractors. So even though the original contract, subcontractors weren't specified, but because of the collateral deed, the third party now became part of the contract, and as such, the future builder owner would be able to sue these subcontractors for any damages. And that would happen even if the head contractor became insolvent, so basically bankrupt. Now, the final aspect that I will be talking about in this video is subcontracting and how the doctrine of privity of contract applies. So subcontracts, that's a contract that's made between the head contractor and the subcontractors. These are separate from the main head construction contract. So the head construction contract, remember, is made between the developer and the head contractor. So the subcontractors are not part of this; they're third party. And if there is no collateral deed, in this case, the subcontractors would remain a third party outside of the contract, and hence they can't be sued. But what usually happens is that the main contractor would remain responsible for any work. So let's say, for instance, there was a principal and the main head contractor. Now it was agreed that the building would be delivered on time, and the contractor, so the main contractor, failed to deliver the building on time. What would happen in this case? Well, the principal can sue the main contractor for damages because they didn't deliver the project on time as specified in the contract. So this was a term that they would deliver on time. But it wasn't the responsibility of the head contractor. So the reason that the head contractor was late was because of the subcontractors. They were late. So what would happen is that the principal would sue the head contractor. They can't sue the subcontractors because the subcontractors are third party, remember? And we said that there was no collateral deed. So they're third party and they're not privy to the contract. The principal would sue the main head contractor, and then the head contractor can sue the subcontractors, and they can do that because they have a contract with them. So the subcontractor in this case is not a third party. And this is referred to, this chain that I'm describing is referred to as the chain of liability, and it's very common in the construction industry.